Congress has recently put forward one of the most far-reaching Social Security reform measures seen in decades. And for once, this is not about cuts. This is not about reductions. This is not about extending the trust fund deadline while benefits slowly diminish. This is legislation that would increase benefits, correct the COLA formula, remove the disability waiting period, safeguard caregivers, broaden benefits for students and children raised by grandparents, revise overpayment rules, and establish new legal safeguards around your personal Social Security information. The legislation is titled the Social Security 2100 Act, also referred to as H.R. 9519, and it was recently introduced in Congress. Today, I am examining everything contained within it, every provision, every figure, and at the conclusion, I will share the single most important action you can take immediately to help turn this into reality. My name is Nancy Ahad. I am a licensed estate attorney. I want to emphasize something essential before we start. This remains a proposal. It is not yet law. It has not been enacted, but it stands as the most thorough Social Security reform measure I have encountered in decades, and every senior across America deserves to know precisely what it contains. Let us examine every major provision. Provision 1, across-the-board benefit increase for all. The initial and most immediately appealing adjustment in this legislation is an across-the-board benefit increase. The measure would elevate the first replacement rate percentage in the Social Security benefit formula from 90% to 93%. Here is what that signifies in straightforward language. Your Social Security benefit is determined by taking your average indexed monthly earnings and applying them through a formula featuring 3 tiers known as replacement rate percentages. The first tier, covering the lowest segment of your earnings, is presently calculated at 90%. This legislation would elevate that to 93%. The outcome is a benefit increase for all, yet the greatest relative improvement would benefit lower income earners, since the adjustment impacts the lowest segment of the lifetime earnings computation. This is not a uniform dollar increase. The sum you would observe depends on your individual earnings history, yet the direction is clear. Everyone receiving Social Security would obtain more. Provision 2, an improved COLA formula that truly mirrors what seniors purchase. At present, Social Security cost of living adjustments rely on the CPI-W, the Consumer Price Index for urban wage earners and clerical workers. This is an index created to track inflation for working-age individuals. The difficulty is that seniors possess notably different spending habits than working-age Americans. Seniors allocate more toward healthcare, prescription medications, housing, and medical services, and less toward items such as employment, clothing, commuting, and technology. The CPI-W consistently underrepresents the categories where senior expenses are climbing most rapidly. There exists a distinct index called the CPI-E, the Consumer Price Index for the elderly, that was expressly created to capture the spending habits of Americans 62 and older. The Social Security 2100 Act would change the COLA computation to whichever proves higher, the CPI-W or the CPI-E for the years 2027 through 2036. If the CPI-E indicates greater inflation in a particular year, that becomes the figure Social Security would apply to determine your yearly increase. This provision by itself could substantially enhance the buying power of Social Security benefits across those 10 years for the millions of seniors whose healthcare and housing expenses have exceeded their yearly COLA increases. Provision 3, a new minimum benefit for lifetime low-wage workers. This is the provision that might prove the most impactful for a particular group of seniors, individuals who spent their entire careers in low-wage positions and whose Social Security benefits today mirror decades of limited earnings. The legislation would establish a new alternative minimum benefit for workers with more than 10 years of covered employment history whose lifetime wages remained low. Here is how it would function. The minimum benefit would be established as a percentage of the federal poverty level, scaling according to years of work with 11 years of work, 62. 5% of the federal poverty level. The scale rises from that point with 20 years 100% of the poverty level, with 26 years 100% with 30 or more years of low-wage covered employment, 125% of the federal poverty level. The present federal poverty level for a single individual is roughly $1,330 monthly at 125% toward the highest threshold. That would establish the minimum benefit at roughly $1,663 monthly, or about $20,000 yearly. And since the minimum connects to the federal poverty level, which updates yearly, this minimum would update alongside it. For an individual who worked 30 or more years at low wages and is presently obtaining a benefit well under this threshold, this provision could constitute the single greatest monthly income rise of their retirement. Provision 4. Elevated tax thresholds for Social Security income. Presently, as much as 85% of Social Security benefits may be included in taxable income if your combined income surpasses certain thresholds. $34,000 for single filers, $44,000 for married couples filing jointly. These thresholds have remained unchanged since 1993, regardless of decades of inflation. The Social Security 2100 Act would elevate these income thresholds, lowering the number of middle-income seniors who incur federal income tax on their Social Security benefits. It does not remove the taxation of benefits completely. As much as 85% could still be included in taxable income, yet the elevated thresholds would offer meaningful assistance to seniors whose incomes have risen modestly since these limits were established 3 decades earlier. Provision 5. Improved safeguards for surviving spouses. This ranks among the most personal provisions in the legislation for me to explain because the income drop that strikes surviving spouses when a partner passes is among the most severe financial events in retirement. I have observed it unfold in practice numerous times, and the existing rules disappoint survivors repeatedly. When one spouse passes, the surviving spouse presently obtains whichever Social Security payment is greater, their own benefit or the deceased spouse's benefit. The smaller payment vanishes completely. For couples where both spouses were obtaining benefits, this can produce a 30 to 40% decrease in household income immediately, while fixed costs such as housing, utilities, and insurance barely shift. Under the Social Security 2100 Act, the surviving spouse would obtain either the deceased spouse's primary insurance amount or 75% of the combined total of both spouses' benefits, whichever proves greater. The limit exists to avoid excessive payments, yet the central aim is evident: avoiding the severe income drop that far too many widows and widowers presently encounter. Provision 6. An additional increase after 15 years on benefits. For seniors who have been obtaining Social Security for an extended period, the legislation contains an extra benefit increase for individuals who have been eligible for benefits for 15 or more years. The increase would introduce gradually, starting at year 16 of eligibility at 20% of the full increase amount, rising each year until year 20 when the complete increase would apply. This provision would cover monthly benefits payable from 2027 through 2036. This acknowledges something essential: that the longer an individual has relied on Social Security, the more their buying power has declined, and the more they require extra protection against accumulated inflation. Provision 7. Caregiver credits for years devoted to family care. This ranks among the provisions I am most pleased to observe in any Social Security proposal. Millions of Americans, a greater share of them women, left the paid workforce temporarily to care for young children, elderly parents, or disabled family members. Under existing law, those years simply appear as zeros in their earnings history. Zeros in the 35-year earnings average that sets their benefit, which means years of truly demanding labor that would have required thousands of dollars monthly to replace with paid care services, register as nothing in the Social Security computation. The Social Security 2100 Act would introduce caregiver credits. Anyone who supplied at least 960 hours yearly of unpaid care for a child under 12, a chronically dependent relative, or a spouse or domestic partner, roughly 20 hours weekly, could have as many as 5 of those years credited in the earnings history. During those years, the Social Security Administration would regard the caregiver as though they had earned 50% of the national average wage for that year, even if their actual income was zero. The legislation would permit SSA to choose the 5 years that would generate the highest benefit for the person. This is not automatic. If the legislation passes, there would be an application procedure with documentation needs. Yet the provision itself represents a meaningful fix to a long-standing structural unfairness in how Social Security regards caregiving. Provision 8, removing the 5-month disability waiting period. For anyone who has experienced the Social Security disability insurance process, this provision holds enormous significance. Under existing law, even after you receive approval for SSDI, there exists a required 5-month waiting period before your initial benefit payment arrives. You may be fully disabled, unable to work, having already completed a prolonged application and appeal process, and you still wait 5 additional months without income. The Social Security 2100 Act would remove this waiting period completely. Disability benefits would commence in the first month you become entitled to them. For individuals who have spent months or years seeking SSDI approval, this is not a minor matter. The 5-month interval has forced people to claim early retirement they preferred to avoid, build debt they could not manage, and confront financial emergencies during some of the hardest stages of their lives. Provision 9, gradual benefit offset for SSDI recipients who resume work. Presently, the regulations concerning working while obtaining SSDI create what advocates describe as a benefit cliff. Earn beyond the substantial gainful activity threshold and benefits can cease suddenly, generating a strong deterrent to try any return to work. The Social Security 2100 Act would substitute the benefit cliff with a gradual offset. For every $2 earned above the earnings threshold, your benefit would decrease by $1. No abrupt termination, no all-or-nothing computation, a steady transition that would enable SSDI recipients to try part-time or limited work without endangering the total loss of their income support. This provision would cover from 2027 through 2036. Provision 10, extended student benefits to age 26. Presently, children obtaining Social Security benefits through a retired, disabled, or deceased parent observe those benefits conclude at age 18 or 19 if still attending high school. The Social Security 2100 Act would prolong eligibility to age 26 for qualifying students enrolled at least half-time in post-secondary education, college, community college, or trade school. To qualify, the student must be the child of a retired, disabled, or deceased Social Security beneficiary, must be unmarried, and must be enrolled at least half-time. This provision would cover from 2027 through 2036. Provision 11, expanding kinship caregiver benefits. Millions of American children are being raised by grandparents, aunts, uncles, or other relatives. Existing law renders it challenging for many of these children to obtain Social Security children's benefits because of limited definitions of who qualifies as a caring relative. The Social Security 2100 Act would broaden the definition of qualifying relatives from grandparents and step-grandparents to fifth-degree relatives, encompassing aunts, uncles, cousins, and further. It also introduces a new avenue for relatives who have been legally granted custody of a child by a court. The child must still reside with and rely on the relative for support. This expansion would enable considerably more of these children to obtain the benefits they may be entitled to under a parent's Social Security record. Provision 12, safeguarding SSI, Medicaid, and CHIP when benefits rise. This ranks among the most practically significant provisions in the full legislation for the lowest income seniors and disabled persons. Under existing law, Social Security benefit increases, including the yearly COLA, can elevate recipients just beyond the income limit for SSI, Medicaid, or CHIP, causing them to forfeit those benefits. This produces a circumstance where receiving more from Social Security actually yields a net financial decrease because of lost health care or supplemental income coverage. The Social Security 2100 Act would omit benefit increases stemming from this legislation from being treated as income for SSI, Medicaid, and CHIP purposes. If you obtain a larger payment because of provisions in this legislation, that increase would not count against you when assessing your eligibility for those programs. How the legislation finances all of this. The most frequent inquiry about any benefit expansion is always identical. How is it financed? And this legislation offers a precise response. First, the legislation would remove the Social Security wage cap after 2026. Presently, earnings beyond approximately $184,500 yearly are excluded from Social Security payroll taxes. Under this legislation, high earners would keep paying Social Security taxes on all of their income, exactly as middle and lower income workers do on every dollar they earn. Second, the legislation would introduce a new 12.4% tax on net investment income for individuals earning beyond $400,000 yearly, capturing income that presently reaches wealthy Americans without supporting the Social Security system. Third, the legislation would combine the Retirement and Survivors Trust Fund with the Disability Trust Fund into one consolidated Social Security Trust Fund. This streamlines the accounting, reinforces the long-term financial outlook, and confronts the fact that the two funds have always functioned as a consolidated system in practice. Data safeguards and operational improvements. Beyond the benefit adjustments, the legislation contains major operational and data protection improvements. The legislation would prohibit political employees from accessing personal Social Security data. It would establish strict civil penalties for anyone who improperly accesses or reveals beneficiary data, and would grant victims the right to sue for at least $5,000 per violation. It would mandate the Inspector General to investigate and report data breaches to Congress. The legislation would also resolve the wrongful death flag issue, the recorded problem where living beneficiaries are wrongly marked as deceased in SSA's system, causing benefits to halt. Under the legislation, victims of this mistake would possess the right to sue for damages beginning at a minimum of $5,000. Regarding overpayments, the legislation would limit the default withholding rate at 10% of your monthly benefit when SSA is reclaiming an overpayment that arose through no fault of your own and without fraud. Presently, the default rate has reached as high as 50%. The 10% maximum would shield beneficiaries from major income interruption during overpayment recovery. The legislation would also require Social Security to sustain at least the staffing levels it maintained as of January 19th of the applicable year and would block field office closures without 120 days of public notice and 2 public hearings. What you can do immediately. This legislation is a proposal. It currently sits in the House of Representatives. It still requires passage in the Senate to become law. The single most effective action you can take immediately is contact your elected representatives and inform them specifically that you support the Social Security 2100 Act, H.R. 9519, and that you want them to co-sponsor it and vote for it. Visit Congress, Gov. House, Gov. or Senate. Gov. Input your address. It will supply the name and contact details for your particular representatives. Telephone their offices, compose a letter, dispatch an email. Share your personal account about how Social Security influences your life. Personal accounts consistently generate better outcomes than form letters. The message is straightforward. I am a constituent. I support H.R. 9519, the Social Security 2100 Act. I am requesting you to co-sponsor this legislation and vote for it. Share this video with anyone you know who obtains Social Security or Medicare. The more individuals who comprehend what this legislation contains, the more voices exist advocating for it to become law. I will meet you in the next video. Subscribe this channel for more latest valuable content.